Had to go for something.
Are they on?
They're muted.
Yeah.
Yep. I'll let them know they're on now.
I guess like they're already in. If I can have everybody's attention, please, if you might start going to your seats, if you would, please. We're going to get started here. Good morning, everyone. I'd like to welcome you. My name is Jim Cimarosa, Marshal of the Illinois Supreme Court, and John Lupton is here as well. He's the Executive Director of the Illinois Supreme Court Historic Preservation Commission. And obviously, he's going to say a few words to kind of give you a little introduction as to what this forum is all about. And then at his conclusion, I'll probably get into some of the security protocols.
Thanks, Jim. Okay, first of all, welcome to Lewis and Clark Community College. I definitely want to extend a great thank you to Lewis and Clark, and particularly President Dale Chapman and Vice President for Academic Affairs Linda Chapman, and Kent Scheffel, Brian McKinney, and everyone who's been so instrumental in helping to put these oral arguments together. The Supreme Court generally has oral arguments in Springfield. They meet 5 times a year. They're in January, March, May, September, and November. But periodically, we go, basically, we call it riding the circuit, which is in deference to the old Abraham Lincoln era circuit riding attorneys and judges who traveled the circuit. So that's what we're doing now, too. And we've done this periodically in the last 5 or 6 years with great success. And really one of the main reasons we do this is to better inform the general public what the Supreme Court is, what it does, the important role that courts play in our lives and in the state of Illinois. Just basically to provide a better education of the judicial department of the state as a third and co-equal branch of government. So again, thank you. I'm glad to see all of you here, and I will turn it back over to Jim for security protocols.
Thank you, John. The court's going to come out about 10:30, so it may be a few minutes, but generally speaking, this is a court proceeding. It's just not in the Supreme Court in Springfield, but all the protocols apply when you're here. Basically, what that means is we're asking the respect of having your cell phone, electronic devices turned off while you're in the courtroom, and just sit as quiet as you can. We know that if you have to exit, take one of the exits here, and we would obviously ask not everybody to take a flood and head out all at one time, because chances are you may not get right back in during the oral arguments. So what we're maintaining here is the least disruptions for the court, and we're hoping that all of you will listen to the oral arguments provided by the attorneys and the justices. And so it's an education process for you as well, as John mentioned to you. And so we ask you that respect, and we're going to get started here real soon. Enjoy. Thank you. I did fail to mention, this is my error. When the justices enter the court, I generally smack the gavel 3 times, and what that is a cue for you to rise. So we ask that you, out of respect for the court, that you rise. And once the Chief Justice reconvenes the court, I'll slap the gavel 1 time, and that's when we're going to request for you to sit. You're going to have the 2 cases, so what will generally happen at the conclusion of the second case, the Chief Justice will also probably say the court is adjourned. At that time, I'll smack the gavel 3 times. We ask you to rise again, and then I'll slap the gavel 1 time for you to sit. Partially the reason for that is because there's a Q&A section right after that, so that you'll have an opportunity, but we're going to wait till the court releases and goes back into conference. After that's done, then we'll probably open it up for the questions and answers. And I encourage all of you to really ask some questions. Spoke to the attorneys here, and they're elated about answering all your questions on the judicial system and the process. Thank you.
Let me know, does this look any better to you? Is this any better, or is that still pretty hot? Check 1, 2, giving you a little bit. Do you need less still? I can give you less. Sure.
Not too bad.
Okay, let me go ahead and drop it more for you. How about this? Is that any better on your recorder? And great. Everybody else good on the record level? Your level's good?
It's the same thing. I assume
Okay, how about that? Let me talk a little bit more. How's your meter there? You guys getting the same thing? What? Really high? But you're good there now.
Turn your volume down. It's like time for me to go.
The Honorable Supreme Court of the State of Illinois.
Mr. Marshall, the Supreme Court is convened.
Oyez, 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 the Supreme Court is convened.
Thank you. Please be seated. Good morning, everyone. Can you hear me? I want to welcome you all to this session of the Supreme Court of Illinois, and I want to thank a few people first. Our staff, first of all, who helped set things up, and then especially Dr. Chapman and the staff here at Lewis and Clark Community College. They've been very helpful. We're very thankful that there are so many people here to participate, to listen to this, and then perhaps to have a chance to ask lawyers questions after the case is over. I want to thank the lawyers for agreeing to come down here. Normally they would be appearing in Springfield at the Supreme Court building, and I would invite all of you at some time, if you have the opportunity, to stop by and take a tour of our chamber, or not of our chambers, but of the courtroom there. We don't let you into the chambers. Today we have one criminal case and one civil case that's going to be heard. Before we start, I want to introduce myself and my colleagues here on the bench. I'm Lloyd Carmire, Chief Justice from the 5th District of Illinois here downstate. To my immediate right is Justice Robert Thomas from the 2nd District, more northern Illinois. To my left is To his right is Justice Rita Garman from the 4th District, Danville, Illinois. To my left is Justice Ann Burke from the 1st District, Cook County. To my far right is Justice Mary Jane Tice, 1st District, Cook County. And to my far left is Justice Scott Neville, Justice from the 1st District, Cook County. There are 7 members of the court, but Justice Kilbride from the 3rd District unfortunately had a death in a close family friend, and he's attending a funeral this morning. However, the proceedings here are all being videotaped, audio taped, and so he and his staff will have the opportunity to listen to the oral arguments. He just doesn't have the opportunity to ask questions as we do. The first case on our call this morning is 123643, People versus Morger, agenda number 17. Counsel, are you ready? You may proceed.
May it please the court, counsel. My name is Zachary Rosen from the Office of the State Appellate Defender, and I represent Mr. Conrad Morger. Now, my argument today rests on Packingham v. North Carolina. And in that case, the U.S. Supreme Court regarded cyberspace as a clearly important place for the exchange of views. The court recognized that for many people, social media websites are the principal sources for knowing current events, for checking ads for employment, speaking and listening in the modern public square, and otherwise exploring the vast realms of human thought and knowledge. These websites can provide perhaps the most powerful mechanisms available to a private citizen to make his or her voice heard. And with that social progress in mind, the court held that to foreclose access to social media altogether is to prevent the user from engaging in the legitimate exercise of First Amendment rights. And for that reason, the U.S. Supreme Court found the North Carolina law to be unconstitutional. And under similar reasoning, I asked this court today to find the similar Illinois law unconstitutional on a facial challenge as well. And so to do that, we must compare the two statutes. And I propose that the North Carolina law is less broad than the Illinois law, but unfortunately neither are narrowly tailored. And that's why the Supreme Court found it to be unconstitutional. And so I talk about narrowly tailoring because this court should apply intermediate scrutiny in considering whether or not this statute is constitutional. And so we should compare the two statutes. I say that the North Carolina law is less broad because it added a requirement that the offender stay off social media websites where the offender would expect minors to be present. No such limitation appears in the Illinois statute.
Couldn't we also think that statute is broader because it extends throughout the life of the person being on while they're a registered sex offender?
Indeed, Your Honor.
This is only during the term of probation, right? Your client?
Yes, Your Honor. Those are significant differences between my case and the Packingham case. Mr. Packingham's condition was in place for the rest of his life, possibly. He was required to register. And indeed, the condition in this case was only for probation. But the probation term was the longest term under the state of Illinois that they allow for 4 years. And that probation term can extend beyond that time for a violation, for accessing social media. But the Supreme Court, the U.S. Supreme Court determined that the North Carolina statute was not narrow enough. And I think this court should do the same here because only considering the time at which the condition lasts is not enough. The court should consider more. Under intermediate...
Mr. Rosen, is the special concurrence in Packingham wrong? Because that special concurrence noted that the North Carolina statute definition was too broad and that it encompassed many websites that did not involve children.
Indeed, the statute was too broad, meaning it was not narrowly tailored. And indeed, with the Illinois law
right,
here...
But when you were indicating that it the statute was more narrow in North Carolina. I thought you said that it only pertained to websites with children, where the special concurrence in the North Carolina case said that it went beyond that it was websites that did not involve children.
Well, that's what the statute said in North Carolina. So if that's what the concurrence said, I believe that there was a mistake there, because the North Carolina statute specifically limited it to websites where the offender would believe minors would be present. Whereas in the Illinois statute, because that limitation is there, an offender would still be prevented from visiting social media websites where we know minors will not be present because they're prohibited from accessing them. There are social media websites out there where you must be 18 years or older to use them, and I discussed them in my reply brief. But I don't think that this court should get stuck in trying to determine what websites are included and what websites are excluded, because just as before the Packingham court and this court, you don't have to answer that question. We only need to determine whether or not the condition here is substantially related and narrowly tailored to serve a significant government interest. And certainly I recognize that there is a government interest here in helping to rehabilitate offenders, in reducing recidivism, and of course keeping our community safe, and particularly the most vulnerable members of our community, children. But as the Illinois statute is written, it doesn't meet all of those goals. It meets them and then goes beyond that. It restricts legal conduct, constitutional conduct protected under the First Amendment, because it would prohibit an offender from exercising political views on any of these websites and from engaging in discourse with other community members. It prevents an offender from speaking and interacting with members of his immediate community online, as well as a much broader community, one that could span the entire globe.
Do you agree, counsel, that the state can restrict prisoners from accessing social media websites?
I think if the statute were more narrowly tailored, we could find a point where I would stop arguing, yes. But as it's currently written, I think it's far too broad. And so this court can reflect on how a statute could be more narrowly tailored. The North Carolina statute provided an example. They limited the websites where only minors would be expected, but the Supreme Court said that is not enough. So we know we need another limitation beyond that. And perhaps the limitation could be that only offenders that use the internet or computers to commit their crimes should be subjected to this limitation. But that wasn't the limitation in North Carolina. It's not here either. Under the Illinois statute, this limitation applies to all offenders. It does not consider the conduct of the offender. And so that's an example of how it may be limited. But I don't think...
Why shouldn't probationers be subject to restrictions on their constitutional rights that would be impermissible if applied to persons who are not under the active supervision of the criminal justice system?
Well, Your Honor, I think it's because of the importance of the fundamental right and the importance of rehabilitation. So, yes, probationers are different from offenders that are on parole, and are quite different from offenders that are off parole but still subject to lifetime registration. But I think that is a difference that should not limit the applicability of the Packingham case. So firstly, Packingham doesn't get into that. They say specifically that that issue is not before the court, and they're not determining whether or not their decision applies only to probationers, only to parolees, only to lifetime registered offenders. So that's the first point. But because probation and parole are on a continuum of possible punishments, we need to consider where the punishment should be strongest. And parole is the stronger medicine. After all, the sentencing court determined that that person should serve a prison sentence first and then serve parole. And so the U.S. Supreme Court has determined that parolees enjoy even less of the average citizen's absolute liberty than do probationers. And so I do not argue that offenders' rights cannot be limited. Certainly they can under many aspects. But the question under narrow tailoring is always how far, how much. And under the Illinois statute, it is just too broad. And so if this court finds it facially unconstitutional, two things can happen. The legislature can try to redraft the statute, make it more narrow, provide some of the suggestions that I made, or they can do nothing. And I say they can do nothing, and it will not harm the criminal justice system or the state's interests, because probation conditions are already quite broad. The government's significant interest can still be served under the current probation conditions, even if this condition is not supplemented after the court finds it unconstitutional. Now, at the back of my brief, I attached Mr. Morger's probation conditions. And I think if we look at conditions 7, 8, 10, and 11, as they're numbered in those conditions, collectively, they can serve the same government interest even if this court finds the ban on accessing social media websites unconstitutional. And that's because under 7, 10, and 11, those conditions prohibit an offender's interaction with minors. Both in real space and in cyberspace, there is an exception for family members, but that's it. It says, do not talk to minors in public, do not talk with them on the internet, do not write to them, do not interact with them. And then the condition number 8 allows the court and the probation office to require that an offender not access or use a computer or any other device with internet capability without prior written approval. And so looking at all of those factors together, the state's goals can still be met. And so even if the condition that prohibits social media access is found unconstitutional, the state can still limit this behavior on a case-by-case basis. And so the state's interests will still be served even if this condition is removed.
What significance does the level of scrutiny that you are arguing have on an overbreadth analysis?
Well, I think it's very significant because we have to remember we're talking about fundamental constitutional rights, and the speech that the government limits with this condition is content neutral. And that's what keeps us in the intermediate scrutiny level of analysis. Certainly not strict scrutiny, because the content is not important here. We're banning all types of speech, whether, as in Packingham's case, it's expressing gratitude to God for a successful court verdict, or in any other case, talking about politics, writing to our governors and elected officials on Facebook and Twitter, and then interacting and speaking on those websites.
Following up on Justice Thomas's question, is the analysis the same for a probationer who may have less constitutional rights?
I think the analysis is the same. Even though the Packingham court did not expressly say that it's the same, that issue wasn't directly before it. And again, I think it's because the rights are just too fundamental. I'm not saying that we cannot keep probationers off of social media networking websites. Certainly we can, but we need to do so in a more narrowly tailored fashion. And as it's written right now, we don't consider the conduct of the offender. And so I know that the state asked for a rational basis review, but I don't think that's appropriate because of the fundamental nature of the First Amendment right here. Nonetheless, we still can turn to cases like In Re JW, who has put forth a list of conditions that we can consider about whether or not probation conditions are constitutional and legitimate and reasonably related to the government's goals. And so we can consider whether the condition reasonably relates to the rehabilitative purpose of the legislation. And here, I mean, what does rehabilitation mean other than becoming a productive member in society, getting a job, holding on to that job, participating in your community issues? And those can be political issues, they can be religious issues, and in this modern era, many of these issues are discussed online. This is where we speak and interact now.
Mr. Rosen, just a factual question here. The appellate court mentioned that the probation officer could lift the prohibition temporarily when appropriate.
Indeed.
Is that factually correct or not?
No, Your Honor, the 4th District was incorrect on that. And I think that the statute makes that clear by comparison, by comparing For example, the probation condition that is marked as number 8, it very clearly says there that offenders can ask their probation officers for permission to use computers and internet. But our condition is mandatory for all offenders. They don't take into account whether or not they use the computer or internet.
Is that one of the changes that you would be proposing that, in your opinion, would make it constitutional, if it could be lifted on a case-by-case basis?
I think that is an attempt at more narrow tailoring. But I am cautious to say that it would still withstand a facial constitutional challenge, because only that one limitation, I think, is not enough. And I think that's what the Packingham court recognized, because there was a bit of a limitation there that I think more expressly communicates the government's interest, is keeping offenders away from children afterwards, preventing that recidivism and aiding in rehabilitation. And so North Carolina said sites where only minors would be expected. And then that whole list of websites that I included in my reply brief, where you must be 18 or older, would be accessible to an offender. But I think that because the court said that limitation is not enough, we know that we need more than that. So perhaps that limitation, in addition to a time limitation, or perhaps taking out the mandatory application to all offenders, making it mandatory only for offenders that use the internet or a computer to commit their crimes, that makes more sense to me. I think that's an attempt at more narrowly tailoring. So, Your Honors, I was discussing what we need to look at to consider whether or not the condition is legitimate. And we need to ask whether or not the condition is related to the nature of the offense or the rehabilitation of the offender, if we're looking specifically at the condition and taking a step away from the intermediate scrutiny analysis. And here, it hinders rehabilitation. It prevents Mr. Morger and others like him, other offenders, from looking for work on social networking websites, from interacting with elected officials and clergy members, and from discussing these important First Amendment protected conversations. But we should also consider the public value in imposing the probation condition and whether it manifestly outweighs the impairment to the probationer's constitutional rights. And I argue under the current statutory scheme, it does limit the probationer's constitutional rights too much. The government's interests are not manifestly outweighed as it is written. And then finally, we should consider whether there are any alternative means that are less subversive to the probationer's constitutional rights, but still comport with the purposes of conferring the benefit of probation. And I think as written here, we're not conferring the benefit of probation. In fact, soon, if this condition is upheld, those sitting in prison will have more rights than those sitting on their probation terms. And that's because, as Justice Carmeier, you asked, well, how are they different? I think it was Your Honor. How are these people different, people in prison or post-imprisonment? In prison, certainly, you can't access the internet, but there's a new law that was passed and will go into effect in 2020 that directs the Director of Corrections and the Secretary of Innovation and Technology to jointly adopt a rule or best practices protocol that permits each committed person in the Department of Corrections institution or facility to access specific approved job search and career building websites. And now I know this wasn't law when Mr. Morger was on probation, and it's not law yet, but I think it does clearly communicate the intent of the legislature and the intent of the people of Illinois to recognize these websites as fundamentally important as part of rehabilitation. And then, of course, fundamentally important as part of exercising our First Amendment rights to speak and interact with people. So, Your Honors, I will conclude saying that this court should find this condition facially unconstitutional, and yet it can still be a win for the state. And that's because the probation conditions are broad and they can still limit this behavior under the current statutory scheme, even if this condition is found unconstitutional. And certainly it would be a win for Mr. Morger and for other offenders, because they'll still be able to access their First Amendment rights in the most fundamental way in our modern era. The public square is now online. And whether or not we personally choose to speak online, we cannot deny that this public square will just become more ingrained in American society. This is the place to speak and interact. This is the place to discuss politics and religion. And of course, it is a place that provides tools for rehabilitation. And so for all of those reasons, I think this court should heed the wisdom from the U.S. Supreme Court and find the Illinois statute unconstitutional as well. If there are no more questions, I'll yield my time.
Thank you, Mr. Rosen.
Thank you, Your Honors.
Mr. Schneider?
May it please the court, counsel. I'm Assistant Attorney General Josh Schneider on behalf of the people of the state of Illinois. Counsel mentioned that probationers are different from offenders who are on parole and even more different than offenders who are in prison. But they are most different from people who are not in custody at all. And that is what this case turns on, is the fact that sex offenders who have been sentenced to probation are in state custody. It is undisputed that the state may restrict the liberty of someone who is in custody pursuant to a criminal conviction in ways that it could not if that person were not in custody, just free out and about in the world. And because of that, whether a restriction would be constitutional if imposed on someone who is not in custody tells us very little about whether that same restriction is constitutional when imposed on someone who's in custody, because those restrictions are governed by different standards. A restriction that implicates the constitutional rights of someone who is not in custody is reviewed under the applicable constitutional standards. So if the General Assembly enacted a law that restricted the First Amendment rights of someone who's not in custody, we would apply the familiar First Amendment standards. If they restricted the Second Amendment rights, we'd look at the Second Amendment standards and so on. But for someone in custody, regardless of the type of custody, whether it's prison, parole, probation, supervised release, if someone's in custody, we apply the same standard, and that standard is the reasonableness standard, under which a restriction is constitutional if it is reasonably related to a legitimate penological interest. Now that's, as you would imagine from the name, a reasonableness standard is necessarily context specific. So something that's reasonable for someone on one end of the custodial spectrum, say maximum security prison, may not be reasonable for someone on the more permissive end, probation under minimal restrictions. An example would be, let's say there was a restriction on the right to possess hardcover books. In prison, that restriction is reasonably related to the legitimate penological interest of protecting the public. In that case, the public is other inmates and prison staff, because hardcover books can be used as weapons, can be used to conceal contraband, can be used to conceal weapons, that sort of thing. That same restriction would not be reasonably related to that penological interest when imposed on someone who is serving a 30-month term of probation, because the security needs in one context are simply not present in another. So when we're considering whether a restriction imposed on sex offenders sentenced to probation is reasonable, such that it passes constitutional muster, we need to consider all of the circumstances surrounding the imposition of that restriction. So, in other words, we're looking at who is being restricted and what are they being restricted from doing, and for how long. Here, the General Assembly has imposed a restriction on sex offenders who have been sentenced to probation that during the term of their probation, they can't access social networking websites as defined by the statute. So who is being restricted is sex offenders who are on probation. This particular population of people who are being regulated here are at a twice heightened risk of reoffending. We know that probationers, as a broad class, are more likely to violate the law than people who have not previously been committed to criminal custody. That presumption is the underlying presumption that supports the entire institution of probation, that will allow this person to be released. They'll still be in custody, but will require them to observe certain restrictions.
Counsel, your opponent has suggested that this court follow Packingham. opinion do you recommend that we follow when we're making our decision in this case?
So the court should not follow Packingham because Packingham is inapplicable. Packingham did not consider a restriction placed on someone in custody. It considered a restriction placed on someone who's not in custody. In that case, sex offenders who had completed all of their terms of probation or parole or prison.
So what decision do we follow? What do you recommend?
The court should follow JW, the court could follow Turner v. Safley, US v. Knights, any of the cases that apply the familiar reasonableness standard. The reasonableness standard is the same regardless of the restriction. The question is just, is it reasonable in that it's reasonably related to a legitimate penological interest? And that's an important distinction because restrictions that are imposed on someone who's in custody, the standard we apply doesn't turn on what the right it affects is. If it's a First Amendment right or a Second Amendment right, the question is only, is it reasonably related to a penological interest? And the First Amendment, although it is certainly an important right that it protects, doesn't take it from outside of the reasonable analytical framework. I direct the court to the Commonwealth v. Power, where the Massachusetts High Court applied the reasonableness standard to First Amendment restriction on probationers, State v. KH-H, where the Washington Supreme Court applied the same. US v. Knight, the US Supreme Court. I'd also direct the court to Farrell v. Burke, where the Second District, then Judge, now Justice Sotomayor, applied the reasonableness standard there to parolees, but there's no material distinction between parolees and probationers. They're both on the spectrum of custody. So I would say that the court should simply apply its familiar reasonableness standard rather than transporting the normal First Amendment analysis that the Supreme Court applied in Packingham to this custodial context.
Counsel, if we agree with you, is there any tension between provisions of the probation orders which require gainful employment and barring people from websites that might lead them to gainful employment?
I would say no, Your Honor. There's no meaningful tension there. Because, and I'll go back to the reasonableness standard because it's important to say what's actually being restricted. We have who's being restricted are sex offender probationers who are more likely to reoffend because they're probationers, and even more likely to reoffend because they're sex offenders, and sex offenders are more likely to offend than other types of offenders. So what's being restricted? Well, here it's important to remember that social networking websites is a statutorily defined term and not sort of fall back on the temptation to view it as we might colloquially. Under the statute, it is only websites where users can create profiles where they upload personal information, photos, their names, other personal information, and on which others can leave comments and messages, and that those comments and messages left by others can be viewed by people who visit the page. So this is a fairly narrow set of websites. Simply having a profile is not sufficient. So if you look at Amazon, there's authors' pages or reviewers' pages or so on. There aren't comments left on those pages, so they wouldn't fall under the statute. Arguably, even Twitter wouldn't fall under the statute because Twitter, if you look at someone's Twitter profile or Twitter page, it has their tweets. It doesn't have other people's tweets posted on their page. Other people's tweets are on their profiles. So this is a far narrower statute than has been suggested. It's certainly far narrower than the North Carolina statute. The North Carolina statute was a statute that prohibited accessing websites that allowed profiles and then also provided some means of communicating with other users. That's not a requirement under this statute. So instant messaging, email, if you look at dating websites, if there's a dating website where you can set up a profile, but people can't comment on your profile, they have to send you messages, well, that's not a social networking website under the statute, and so that's not prohibited. And the reason that's not...
Analysis really depend on getting down into the weeds between Twitter versus Amazon. The argument has been made here that your opponent has identified what he would say are legitimate, really positive uses of social media that could, in fact, assist a specific probationer in rehabilitation. there are many opportunities for all of us to participate in healthy interchanges, even on social media. And your opponent suggests that even if he doesn't say this, but even if you're talking about a reasonableness standard, aren't there reasonable ways that people need to participate in the community discussions using social media that this defendant and others like him would be denied?
Well, there will certainly be some websites that he's not able to participate on. Looking at the websites that he is prohibited from participating on, that's certainly a restriction, but that restriction is reasonably related to a legitimate penological interest, because the legitimate penological interests that are served by probation are not only the rehabilitation of the offender, it's also incapacitation, protecting the public from the risk of recidivism that is posed by the offender being rehabilitated in the community. Because certainly the General Assembly need not make probation available as a sentencing option. There would be no problem with the General Assembly saying if you committed one of these sex offenses, it is 3 to 7 years and probation is simply not among the sentencing options. They've elected to balance the policies differently and tilt them more towards rehabilitation, but with the understanding that if we're going to have these people being rehabilitated in the community, we need to make sure that they can be rehabilitated safely in a way that does not unacceptably threaten the safety of the public. So what they've chosen to do that is by restricting their access to these particular websites. And that is a reasonable approach, because these particular websites where someone creates a personal page, posts their personal information on that page, and then other people comment on it, and all of it is visible to visitors to that page.
You were talking about, at some point, about rehabilitation. In what sense are you arguing that the statute and the prohibition on the use of social media rehabilitates, or is it merely for the protection of the public, which is, I think, what Packingham said?
It's both. So it is
How
reasonably...
does it rehabilitate?
I beg your pardon?
How does it rehabilitate?
So the reason that the General Assembly identified these particular websites is these are the websites that provide the opportunity for offenders to identify, locate, and target potential victims.
In this case, the defendant did not use the internet in the commission of the crime. What makes this different from any other crime? Why shouldn't anybody else be barred from use of the internet when the underlying offense had no direct connection with the internet?
Well, as the court explained in minutes when the court upheld a requirement that registered sex offenders who are not in custody disclose their internet whereabouts and internet aliases, the court said that it was undeniably directly and effectively serving the state's substantial interest in protecting the public. And it's because the General Assembly reasonably determined that sex offenders are, even if a sex offense does not involve the actual use of the internet, right? It's not grooming, it's not indecent solicitation of a minor or indecent solicitation of an adult. That doesn't mean that the internet does not provide opportunities for real life in-person offenses. So for example, if an offender goes on Facebook and sees pictures of a child on some page, they're able to then, going through that person's posted information, the comments from people on that page, identify actionable intelligence, essentially. Day-to-day routines where these people are. Now you can actually get current physical location data as people's phones upload their physical locations, or they tag in on locations or that sort of thing, which can then be used to commit an offense later. The fact they haven't used it for that purpose in the offense for which they're convicted doesn't mean that's not a legitimate concern of the General Assembly and that doesn't pose a risk to the public.
Can a person who's been convicted of using the internet to scam someone out of money, can they be barred from using the internet under current Illinois law?
I don't believe that there is a mandatory probation condition for people who've committed fraud using the internet.
Doesn't that seem to be more related than the facts here in this case?
Yes, that would be more directly related to that particular class of offense. But that having been said, the General Assembly has enacted the legislation that it felt was necessary. It has a residual clause, for want of a better word, under which a judge may impose discretionary conditions as appropriate based on the reasonable needs of the nature of the offense, the rehabilitation of the specific offender. But the General Assembly apparently felt that it was a greater priority to enact this legislation than that legislation. And certainly the lack of legislation prohibiting people who commit wire fraud online doesn't mean that this particular restriction is unconstitutional. The General Assembly need not prevent every possible harm from every possible vector to have any of their restrictions pass muster. To answer your question about how does it relate to rehabilitation and protection? It relates to protection because it prevents offenders from accessing these opportunities to find victims and potentially use that information to abuse them. And as the concurrence in Packingham points out, the information on these sorts of websites can be extensive. And one of the problems with these particular websites is the sex offender can access this information without alerting the persons whose information it is. The sex offender can simply go to the website and see all of this without registering their presence. And one of the interests that the court recognized in Minnis is the interest in protecting the public by having the public essentially have a fighting chance, know whether they're interacting with a sex offender, and have the opportunity to opt out of that interaction. Here, they don't even know that they're interacting with someone because there is no interaction. Their information has been exposed to a sex offender, and they don't know it. So it provides opportunities to reoffend that the General Assembly was reasonably concerned about. But it also promotes rehabilitation because an opportunity to reoffend is a temptation to reoffend. And it's important to remember that this restriction is narrowly tailored temporally. It's only up to 48 months immediately after conviction, when the likelihood of recidivating is at its highest. The person hasn't been in any sort of rehabilitative custody yet. They're as close in time to the actual commission of the offense as the criminal justice system is going to get them. And so the risk of recidivism is at its peak. During this narrow window, for this narrow class of websites, the General Assembly decided, in the interest of protecting the public and fostering a successful rehabilitation, it's necessary to prevent these sex offenders from having access to this type of information.
Is the fact that under Section B18I, where there's permissive barring from the internet based upon a probation officer's discretion, isn't that an indication that the complete ban is not narrowly tailored?
No, Your Honor. The discretionary ban is actually broader, arguably, since it is not simply this narrow class of social media websites. It would be all websites that involve interaction, including email, including news websites. That's a total ban, and it's subject only to the discretion of the probation officer. So that would not be it. It is a bit odd that they suggest that because this narrower restriction violates the First Amendment, it can be safely struck down because the even broader restriction would take up the slack. And I would note that they also challenged the broader restriction in the court below. So we can't be confident that that would necessarily withstand withstand attack.
I have some questions about the issue about probation officers' discretion. Certainly some of the cases across the country that have dealt with similar statutes have found their statutes to be constitutional because it allows for some kind of discretion of probation officers to allow some kind of legitimate use of social media. Now, first of all, do you agree that that is not part of our statute here? And then secondly, what do you think about the California Supreme Court reading in such a limitation into their statute?
So I think it is a relevant consideration because although we need not have the least restrictive means available to pass muster, it is a consideration whether there were readily accessed less restrictive means. I don't think it's appropriate to, or the court has certainly declined to interpret statutes in a way that effectively rewrites them, adding exceptions where they're not provided by the General Assembly. So I would suggest that this is similarly a circumstance where the General Assembly has made a clear statement as to what it wanted to effect. It wanted to prohibit access to these specific types of websites. And if it intended that be effective. If the court thinks that what it intended to do was unconstitutional, as the court previously has, it declined to rewrite the statute for the General Assembly. I'd like to briefly address the point that there wasn't a nexus with a specific offense in this case and in doubtless other cases. There's a string set of federal cases that defendant has provided in his opening brief at pages 13 and 14. But all of these cases are federal cases looking at judicially crafted discretionary conditions of supervised release under 28 U.S.C. 3553A. And the first case in that string site, U.S. v. Burroughs, on the page cited by defendant, page 243, says, quote, "If internet restrictions were appropriate for every defendant convicted of a sex offense against a minor, we think the sentencing guidelines would say so." Well, here the General Assembly has said so. The General Assembly made the reasoned determination that for sex offenders, this restriction is appropriate. And they did not find that the specific nexus was necessary to make that conclusion. Had there been a similar statute in the federal cases, those cases would not have gone any further, because there would not have been any room for the judge to have crafted that particular condition. For no further questions, we ask that you affirm. Thank you.
Thank you, Mr. Schneider. Reply, Mr. Rosen.
Yes, Your Honor, briefly. Your Honors, I'd like to touch on a few short points. Firstly, I'd like to address the comments from the state about recidivism. Your Honors, I do not think that the social statistics support the assertion that sex offenders recidivate at a higher rate than any other offender. I've cited to news sources on page 16 and 17 of my reply brief. One study observed nearly 10,000 male sex offenders for a follow-up period of 3 years and found that these offenders have lower rates of recidivism than non-sex offenders. And I think it's important to remember that while that study is short in time, we're talking about our concerns of a probation period that only lasted 4 years. So I think the study applies quite well. Moreover, I don't think the state has addressed the fact that most youth who sexually offend never repeat their harmful conduct. And while this case, we're not talking about a youth, we are talking about a very young man who we know the brain development is still ongoing at that age. And so I just wanted to address that at the outset. And I don't think that the risk of recidivism, specifically because these offenders are different for some reason, should be considered by this court. I also don't want the court to get distracted on what websites qualify. I think we can all agree that Facebook is a social media website that would qualify, and even if the Illinois statute specifically mentioned Facebook and limited it only to that website, we would still be making this facial constitutional challenge. Even if one website qualifies but prevents an offender from exercising his or her First Amendment rights in this broad ban, it has gone too far.
Mr. Rosen?
Yes, sir.
In your initial argument, you talked about if this court determines that the statute's unconstitutional, what lies ahead in the legislature. And you made a couple of suggestions of what may occur. The thought comes to mind, might you win the battle and lose the war? I mean, might the legislature disallow probation for these kind of offenses if it feels that it isn't allowed to craft restrictive conditions that affect speech?
Indeed, that's certainly possible. I know not what the legislature will do, and fortunately, under our co-equal branches of government, if that is the legislature's response, I would hope that another case brings the issue to the court to reconsider whether or not the legislature has overstepped again. Your Honor, the states have also argued that the time limit is important to consider, and they say that it's only 48 months that are limited in the case where an offender has its full probation term sentenced. But that's 4 years. That's a whole presidential term. That's time for governors and our elected officials to tweet thousands of tweets on Twitter. We see many every single day, and for that entire period of time when the individual is supposed to be rehabilitating and reintegrating in modern society, they're banished from participating in modern society, from exercising their First Amendment speech rights online, just as we all do. And so I don't think that the time limit directly should relate to this court's consideration of whether or not the condition is constitutional or not. The state has also argued that a discretionary ban is not broader, but I think that's just flatly untrue. I don't think that logic applies there, because if it's discretionary, it will affect far fewer offenders than if it is mandatory. And that's why the statute is too broad. That's why it's not narrowly tailored, because it affects every single offender, and it does not consider whether or not the condition will help rehabilitate the offender. That's what it really comes down to, is that these are rights that offenders should be able to exercise to assist in their process of rehabilitation. And if it's kept from them for a week, a month, for years, it's too long, because we tell them, go out into society, make something of yourself, get a job, find a place in your community where you can live a lawful life, and then we put stumbling blocks in front of them. Say, don't use the tools that everyone else uses. You're prohibited. And even if it's for a short period of time, I still think it would negatively affect that individual's rehabilitation and reintegration into society. Finally, Your Honors, I want to address the point that in custody and out of custody is different. Indeed, it is, but they are all part of the rehabilitative process. Whether you're in custody or whether you're put on probation, that is the first step in rehabilitating. You've been found guilty or you've admitted guilt, and now it is time to build yourself back up. And so while it is different, it doesn't mean that these limitations, no matter how broad, are acceptable because you were in custody or because you got probation. You can lose some rights, but again, the question is how many and to what extent? And under the current condition, it's mandatory, it's broad, and it's sweeping. And that's why the facial challenge should be addressed under the intermediate scrutiny standards. And so, Your Honors, for those reasons, if there are no more questions, I ask that you find this condition facially unconstitutional, and I urge you to look at the other probation conditions to realize that even if this condition is struck, the state's interests can still be well served. The public can still be protected. The probation conditions limit contact with minors in all spaces, real space and cyberspace. The conditions allow the court and the probation office to provide for specific exceptions in using the computer and using the internet. And so this statute here doesn't do anything else. It doesn't do anything that the probation office can't already do. The only thing is that it makes it mandatory for all offenders. And I don't hear the state arguing that it should be mandatory for all offenders for any specific reasons. It should be handled on a case-by-case basis, but under the current statute, that is not allowed. That is why the law is too broad, and that is why I ask this court to find it facially unconstitutional, just as the Supreme Court did in North Carolina v. Packingham. Thank you, Your Honors.
Thank you. Case number 123643, People v. Mortar, will be taken under advisement as agenda number 17. Mr. Rosen, Mr. Schneider, we thank you for your arguments. You are excused. However, if your time permits, we'd like you to stay around afterwards and partake of a conversation with the people in the audience. Thank you. I would also indicate that, and you may have noticed there's a light on the table where the podium is. Counsel are limited to arguments 20 minutes from each side and then 10 minutes of rebuttal, even if we ask a lot of questions and interfere with the train of their thoughts and arguments. The next case is number 124472, Colin Dubecker versus Andrew Wu, agenda number 18. Counsel would come forward. Okay. We are fortunate to have with us today also sign interpreters, and those of us who are speaking needs to speak clearly into the microphone so that they can hear it. Their backs are turned to us. And Council, I thank you for being willing to travel here to us in Southern Illinois to make these arguments today. Mr. Ring, when you're ready, you may begin.
Good morning, Justices, my opponent.
Good morning.
My name is Burton Ring. I represent Colin Dubecker. There are a number of things that makes this case rather interesting. It's under the criminal code, but it has some civil penalties associated with the wrongful conduct contained in the statute. In addition, it has a key time aspect as well, where not only is the victim allowed to recover the money he lost in gambling, but allows anyone in the world to go in that person's place, doesn't file suit within 6 months to sue for that gambling loss trebled. That's a key time aspect. So it's a very interesting case in that regard. In that case, also, we have to discuss that there's the remediable aspect to the case for the victim to recover the money he lost, and the penal aspect, which allows the treble of the damages that the victim lost when anybody else sues on behalf of that victim. The record here is quite simple, and we need to discuss the record, as the record is very similar to the 104-year-old case of Zellers that was decided by this Illinois Supreme Court in the last century. The record here shows it's contained through a court reporter, even though it was a pro se complaint, and it was a very detailed complaint as well. Mr. Dubecker and Mr. Wu entered into a head-to-head DFS contest, daily fantasy sport contest, that is very popular these days. It was operated by FanDuel, and they recently, as you know, merged with DraftKings. And that was contained in the opinion by the Illinois Attorney General when they both merged together. And that in FanDuel, which involves a prediction of certain NBA athletes in games to be played that day. So the parties would then decide on which contestants they would pick out, which athletes they would pick out. There's a salary cap, and they're limited by the salary cap which players they would use. In Mr. Dubecker's case, he used some pretty good players. He used Mr. Dwayne Wade and Mr. LeBron James, although he did lose. Each of the contestants, Mr. Dubecker and Wu, they paid $100 plus a $9 service charge, a total of $218. Mr. Dubecker's players lost, and that meant that Mr. Wu was awarded the $200, the $18 going to FanDuel. In this case, it was about a 90% amount paid out in the total pool. FanDuel uses points to assign players based on their performance of games that night. So they use the statistics for what they did in the games that day, that night, or the previous night. And those are the elements completely out of the wager's control of how they do in that evening's match. Injuries, coaches' decisions to play them, weather issues if it's an outdoor sport, and other factors would leave whether or not the player scores any points in the game at all, or how many points he scores. Participants build their teams in limitation to the salary caps. FanDuel can determine the money awarded, and they formulate the money pool distributions. So they can do that various ways. In head-to-head competitions, it's exactly what each party puts in. So you can decide if you want to do a head-to-head competition, just one party on the other side. You can put that in when you input your information into the internet. If a participant's roster generated enough points to be the highest scoring rosters in that DFS contest with a specific number of rosters, it must outscore varying from contest to contest. A participant will win a % of that money pool. So there's other types of games that the DFS pool does award. There can be as many as leagues during a number of seasons. It could be throughout the season. It could be a daily sport. There also could be a number of wages you can make as well, anywhere from $1 to $10,600. Now, here we have a situation where the We call this the Loss Recovery Act, and the Loss Recovery Act has been amended, the last time being in 2009. And that was when the Loss Recovery Act was amended with the Video Gaming Act. And that's important in a number of ways. When it was amended by the Video Gaming Act, there was an exclusion, so if you lost money on the Video Gaming Act, you couldn't sue under this Loss Recovery Act. And even though we have new legislation that starts next year, the General Assembly still did not do any more amendments to this Loss Recovery Act. And we have to talk about the Video Gaming Act because it's very similar to the situation here, which the lower court found to be the impediment to why we lost the decision. And then when you go into playing video gaming, it's usually the owner of that bar or restaurant or store that owns and gets the money when you put in and lose in the video gaming machines. They don't own the machines, but you put the money into the machines. So that's another third-party intermediary. And the Zellers case is very similar as well. When that person went and gambled at the casino in Zellers, the other employees were paid by the casino owner to wager with the person who lost money in Zellers. So again, a third-party intermediary. So here we have, when the General Assembly put in that the Video Gaming Act is an exception to this Loss Recovery Act, they knew in fact that there would be a third-party intermediary, just like in Zellers. And so here the lower court decided because it was not a direct person-to-person gambling situation, that's why the act didn't apply to daily sport fantasy betting. But under the rationale of including the Video Gaming Act as an exclusion in the Zellers decision, the lower court's decision is incorrect.
What is the conflict, counsel, between the two acts?
I'm sorry?
What is the conflict between the two acts?
The Video Gaming Act?
The Loss Recovery Act and the Video Gaming Act.
So there's no conflict at all between the two acts. It was just that under the Loss Recovery Act, if you lost money in playing a video game, then you would be able to sue the owner of the bar or restaurant for the money you lost in that machine. So what the General Assembly did is they said, no, we want to encourage gambling in this Video Gaming Act, so that's why they put the exclusion in there. And that's similar to what's happening in the legislation that was just passed recently by Governor Pritzker. Here they have a new section of the Sports Wager Act that doesn't start that allows this kind of wagering, daily fantasy sport betting, only if certain conditions are met. And so
generally under the sports betting is that the bettors don't even know each other. In this particular suit, they did know each other before, but it could happen most of the time where they don't even know each other. Is that correct?
It's very possible in these kind of internet gambling sites that the bettors don't know each other at all. Here they did know each other. Mr. Dubecker's screen name was pretty obvious. It had most of his name, even though Mr. Wu's name was not as obvious. But the people knew each other, and most of these sites have regular gamers on there already, and they may know each other. There's other sites that get together and discuss strategies on these sites. But that's another problem the lower court decision did not like, is that maybe they wouldn't know each other. But even if you're playing poker, and like in Zellers, an underground casino, you really don't know everybody who's sitting at your table. You might know their first names or their slang names, but that shouldn't prevent the lawsuit from going forward. The Illinois Supreme Court Rule 224 allows you to learn the identities of the other people's names before you sue them in another action. And so there's vehicles to allow you to learn the names, that there should not be an impediment to having the right of this statute to gain your money back.
Do we take into consideration the recent passage of the Sports Gambling Act in connection with this case?
That does have a lot to do with, like it's the previous question the judge asked in the last case, we could win the battle but lose the war. But don't forget here, the General Assembly is supposed to be starting next year, and there's certain restrictions for these daily fantasy sport betting websites to pay a certain fee and to do certain things under the regulations that are not completely formulated yet.
Will people still be able to use the Loss Recovery Act if they lose in sports gambling?
I believe right now as it stands, yes, they can still do that, but if they're going to allow these daily sport fantasy bettings to be regulated, I think that would be a conflict between the two statutes, saying on one hand, they can have the right to have a license, but they should, the General Assembly then should do the same thing they did when the Video Gaming Act came out. They should have another exclusion here. So it brings me another point that the General Assembly makes laws with the knowledge of them knowing judicial decisions as well. Now here, the Attorney General's opinion about that this is illegal gambling, these daily sport fantasy betting is illegal. And that opinion came out by the Illinois Attorney General December of 2015. And that was addressed to two legislators. And after that, the General Assembly still did not do anything regarding amending the Loss Recovery Act statute at all. Then this lower court opinion came out in December of 2018. And this was a published opinion, the lower court, where we lost. And the new Sports Wagering Act didn't come out till June of this year. So again, the law is clear that the legislators presume to act with knowledge of all prior legislation and all knowledge of judicial decisions, and still have failed to act to contain any new exclusions. And so therefore, this court still has to go along with what the General Assembly statute says under the Loss Recovery Act. Turning our attention also to, this is a criminal case. It's really coming out of the criminal code. And as I discussed in my first comments, that this is a remedial statute for the recovery of the money by the victim. And when you look at, as I pointed out in my first part of the brief, is that when you look at the criminal statutes, you have to look at what the purpose is of the statute. And it's clear from the section of where the criminal code is for this statute, it's the public decency section, it's really meant to stop gambling, to get away with gambling, to curb gambling. And it's just as Posner pointed out on one of his federal court opinions, it's sort of like this case is heads I win, tails you lose. And I agree with that, of course, because if you go gambling and you lose $50, but you can soon get your $50 back, is what Justice Posner indicated. However, the intent of the statute was to get rid of gambling, only allowing the exceptions contained by the General Assembly. And as the appellate court said in the lower court opinion, is that the social norm is to allow more gambling and then to stop gambling. We agree with that, however, only subject to the specific requirements of the Illinois General Assembly. And that is meant for like taxing purposes. And there's some examples, as my opponent put down in the legislative history of this Loss Recovery Act. There's a restriction about boxing when this act came out in the 1800s. And there was some restriction on boxing, having a fist fight in the street. However, now we have much higher regulations, stricter regulations about boxing. For instance, you have to get a promoter's permit to be a licensed promoter. You have to have a fee to have the actual boxing event. So just today, we have many requirements to be a video game act, to have those facilities in your bar or restaurant. There's taxes associated with those machines. So we have a lot of tax revenue coming out. Here, there's no tax revenue coming out of the DFS gaming sites, nothing at all. There's no restrictions, no regulations. So the social norm is to accept more gambling subject to the Illinois General Assembly's restriction and requirements. And so right now, the requirements set forth in the Sport Wagering Act that is to begin the next year, but at this time, it doesn't affect what took place 3 years ago. And at this point, there's no restriction or new exception under the Loss Recovery Act.
Now,
For
the fact that there's a third party involved here in FanDuel, you think that doesn't make any difference?
Well, the third party, that was the reason why the appellate court and the trial court ruled against us. However, when we really look at the third party intermediary situation, the Zellers case had that as well. and that didn't seem to be an impediment to the loser and the victim getting his money back in Zellers. In the Video Gaming Act situation, and that's the same thing, you're putting your money in this machine, and the machine gives you a ticket to get your money back from the owner of the restaurant, or there's a machine to get your money back, so there's another intermediary. But let's look at what really takes place in today's norm. For instance, the regular real estate transaction. In the old days, you had to actually give your deed to the buyer when you're selling your house or any piece of real estate. That's required for a transfer of delivery to the deed. Nowadays, of course, every real estate transaction has a title company. So when you sell your property, the seller puts the deed in the middle of the pile in the closing room, and then the title company takes their deed and records it. Very rarely, if at all, does the seller actually hand the deed to the buyer, and that should be the effective way of delivery of the deed. But that never happens in today's society. There's always an intermediary in almost every situation, from catching a cab, catching a Uber, a real estate transaction, video gaming, or anything else today is with the mobile application of a computer. So the intermediary should not be at all an impediment to this kind of situation. In the old days, of course, you would have a friendly card game. But a friendly card game is, and even persons holding the chips in front of them, and there's a banker in the room, that still wouldn't apply. As Justice Posner pointed out in his decision then, is that you're not going to be invited back to that card game if you're going to be the one suing everybody else at the card game. So really, this law is really meant to have a broader aspect than just your friendly card game at somebody's house on a Friday night, because you'll never be back invited to that card game.
The defendant seems to argue that the act is intended to allow for recovery between persons known to each other, and I think the appellate court touched on that too. What's your response to that?
Well, in this case, the people happen to know each other before they got involved in the gaming, and some of Mr. Dubecker's screen name was quite obvious, but I don't think that it should be an impediment at all to whether or not there should be a recovery to the victim. And you could have an average card game and people might not know each other at the card game as well. And so in any ways, you can even find out with the internet these days, it's pretty easy to find out people's names. You can do an easy search to find out who's really behind that screen name. And so that should not be an impediment that maybe they really don't know that person. And like I said before, you can use Illinois Supreme Court Rule 224 to find out the identity of the defendants in this particular case, or cases similar to this.
Mr. Ring, doesn't statutory construction apply here? And if we look to the legislative intent for the Illinois Loss Recovery Act, I mean, that was a pre-Civil War statute. So I don't think the parties or the legislature could have happened to have thought about the internet. They presumed, I'm sure, that the gambling would be between two people who knew each other. Here, just because these two people knew each other, but it's been in place for a decade under the fantasy sports, where thousands of people did not know each other. And how would they ever find out who each other was, who they voted against or bid against?
Well, in respect to the age of the statute, the Illinois General Assembly has had ample opportunity to repeal this or provide further exceptions. There are 12 exceptions in other parts of the statute, and they had an opportunity to add one more exceptions to the statute. They did not. After Attorney General Lisa Madigan's opinion came out in 2015, the General Assembly had another opportunity to amend the statute or repeal it. They did not. After the lower court's decision in 2018, the General Assembly had another chance to change or repeal this law. They did not. And so just because the statute is old, it's under the public decency section, and it could be amended at any time. But it's here today, and it should be enforced. The Attorney General has indicated that it's illegal gambling under that statute. So the fact that people don't know each other could learn through some ways. The law is fluid and should adjust and make those adjustments for how the society is run. I think my time is running out. If there's no more questions, thank you.
Thank you, Mr. Ring. Mr. Gatz?
May it please the court, my name is Bill Gantz and I represent the appellee, Mr. Andrew Wu. The plaintiff here is asking this court to interpret and apply a 200-year-old statute, which to boot is a qui tam type statute, in a very broad manner generally to apply to a very new situation, the virtual and anonymous and global world of the internet. Counsel moments ago, he opened by saying, anyone in the world could sue under subsection B. Therein lies the crux of the problem. The qui tam statute here is undoubtedly penal in nature and it should be construed strictly. The plaintiff here is asking that basically for a ruling that any person could sue any other person involved in the activity of DFS without really defining or putting in the record what that is, on the premise that the activity is unlawful. The Attorney General had 4 years to prosecute and make good on her opinion if she chose to do so, and in fact, when confronted with the lawsuits challenging that opinion, she in fact withdrew them. The legislature had the opportunity to take whatever action it wished to do with respect to DFS, and the only thing it did was to authorize it in a massive gambling expansion. The current state of Illinois in terms of gambling was predicted by the court below. It anticipated that there were bills pending, and that is one of the reasons why it didn't seek to expand the reach of a penal statute and a penal code to this particular situation, which could not possibly have been anticipated by the drafters of this statute when it first went into effect in 1809. The expansion of this particular liability under the code truly does ignore the intent of the drafters. They could not have envisioned anything other than an illicit poker or faro or some other type of gambling that was conducted in the state of Illinois at the time. It ignores the language of the statute and this is a case about statutory construction, and we've had courts construe this statute and found that it required a direct connection between people. And it also ignores the fact that the application of this statute beyond that to this environment would undoubtedly produce seriously unconstitutional defects. The plaintiff has not responded to our arguments and makes no argument how anyone in the world could use this statute to sue anyone in the world. This is a global, virtual, and anonymous environment. And the appellate court below, following up on Justice Burke's question, most of the time people don't know each other on these websites. And that the appellate court didn't focus on only that whether this person knew each other or not. The problem was trying to apply this statute to this virtual environment where it was clear that many, many people would not know each other, that many, many people were not even in the state of Illinois. And in fact, the record in this case doesn't even establish where the people were at the time that they were entering into this contest. So an argument for the sea change, opening up the courts to hundreds of thousands of suits, or a cottage industry where lawyers or people are sending letters to anyone they can think of, or in fact then try to sue the DFS websites under Rule 224, which I clearly cannot apply. It's just untenable. The court here, as we pointed out, in terms of the record itself, there was a lot of argument moments ago about all of the different activity on the DFS websites. The only type of contest that's at issue in this case is a head-to-head challenge, which, according to the record, Mr. Du Becker said he created. That's the language from his complaint that they've cited as the source of evidence. There's no evidence as to actually how players were selected, how many players. The one particular exhibit Exhibit 1 is like a salary card, and it's the only evidence of what actually happened in this game. There's no evidence of how the game was administered, how much skill was taken. And to ask the court to accept the premise that it should apply generally to DFS on this record is really not possible, because there is not a record for all of the activity that these DFS websites apparently have. This is an incredibly popular and very prominent type of activity in the state of Illinois, and no court has ruled it to be illegal. There was no prosecutions, and in any of the 31 states that have similar anachronistic qui tam statutes, not one of them has applied this type of rule. The one case, I think, which is very interesting that we've cited to is the Humphrey versus Viacom case. And in that case, the court, it was a district court in New Jersey, but they were considering basic actions brought on behalf of, under a subsection B type claim, to recover all of the losses for all of the losers in 4 or 5 different states, including Illinois. And that court has a really interesting perspective and went back to the history and cited to Illinois decisions, including the Casino Queen case from Illinois. The origin of these qui tam statutes is to protect family members. It goes back to 1800, and it was to protect the dependents of people, of men or women who went to poker games and lost money. It was to protect the dependents. It wasn't to create a cottage industry. It was also in the context of a time when Illinois was still a territory and didn't have a mobile police force and district attorneys and police officers and attorneys general that could enforce the laws of gambling. There's no longer the case for that either, which is another reason why this statute should be strictly construed. The record on this case simply isn't, the court could decide this case on the lack of a record of the predicate act of gambling. If we look at the actual, what does that mean to be strictly construed? It does mean you look at the intent of the drafters. It does mean that you consider the time and purpose of the statute. You do consider exactly what was going through the mind of the legislatures. The last time that this act was substantively changed was, and it's a little difficult to get to the judicial history, but in the 1961 version of the statute, the amount states $50, which is what it currently is. It is unchanged since 1961. And I'm not arguing that this statute may not still have some relevance to a game that is envisioned by the drafters, such as a poker game at someone's house in the state of Illinois between persons who generally know of each other and the game. This is a completely different situation and a massive expansion of the Loss Recovery Act to a situation which no one could have possibly imagined, even in 1961. The appellate court in this case did involve itself, as this court should, in an actual construction of the statute. And the appellate court did observe that it appeared, based on the language, that it required a connection between a person, because a person must pay a person. There must be activity between two people. The Langone case, which is a federal case, which the Dubecker Appellate Court also cited to, dove in a little deeper, and we've set forth this argument in our brief, so I don't want to belabor it, but the use of the term "the winner" in both subsection A and subsection B under the Chicago Manual of Style, used by the court as a construction aid, means that the person is a known subject. You would use a winner if it were not the case. So there is a literal construction why you must know the winner. Another construction reason why a person is required to plead and prove and know who the winner is that if you consider a subsection B claim, and there are several cases that hold this, you cannot bring a subsection B claim unless the person entitled to do it, the loser under subsection A, has not done so. And the courts have routinely dismissed cases where people said there was a loss, but they could not identify the loser under subsection A, and they could not state the amount of the loss, and they couldn't state that a claim had not been brought by that person within 6 months. That's another practical reason why the courts have required and dismissed the subsection B type lawsuits where a person could not state who the loser was and identify them. Another reason to strictly construe that requirement is that was exactly what the intenters would have been dealing with. They could not have envisioned this type of environment.
You mentioned earlier, or you alluded to the fact that this act, the gambling here, if this is gambling, was never found to be illegal. Does that matter in the interpretation of the Loss Recovery Act?
Well, it does, because in order for the plaintiff to sustain its case, it must show that there was a predicate act of gambling. And in this case, actually, the predicate act of gambling has to be committed by Andrew Wu, not FanDuel or any other DFS websites. He is the one who must have engaged in gambling. And Andrew Wu was a participant along with hundreds of thousands of people in an environment where he could not have conceived that he was involved in an illegal activity on a website that had been open and obvious for 4 years with hundreds of thousands of people with 0 prosecutions, including, we pointed this out, under federal law, there's an express carve-out under the Unlawful Internet Gambling Enforcement Act that allows DFS websites to operate nationally without violating the Wire Act. So this is the environment that they wish to extend the statute to. Andrew Wu had to knowingly, under subsection A, knowingly participate in a game of skill or chance that was not subject to an exception under subsection B.
So it is your argument that to recover under the Loss Recovery Act, the gambling has to be illegal?
Absolutely, Your Honor. There must be a predicate illegal act of gambling. And this is one way in which Zeller and other older cases, they're appropriately decided, but they're not terribly relevant, because in Zeller, for example, everyone was at some place in Illinois. Everyone was at a house, and they were engaged in a clandestine activity of poker that everyone in that room would have known was clearly illegal. And that's the difference here. This is not a clandestine activity. This is an open activity that the state of Illinois tolerated and never prosecuted and has now legislated into effect. They chose to regulate it. They studied it. If you look in our appendix at page 40, the reason why Attorney General Madigan issued her opinion was at the request of the legislature. And I think it was Representative Drury, and he sent the letter and he said, we'd like to have your opinion. We anticipate in 2016 that this will be coming up, this issue, and we are also, we don't need an opinion, but he was clearly contemplating how to treat these sites from a matter of public policy and whether to tax and regulate them.
Mr. Gantz?
Yes, sir.
Mr. Ring indicated, that, I think in response to Justice Garmon's question, that they did know each other. The plaintiff and defendant did know each other in this case. And I think earlier you said they had to know each other, but your position is that's not dispositive, however.
Yeah, it's not dispositive, and it's actually not the bright line test that the appellate court used. It did observe that maybe, well, it assumed that Mr. Dubecker and Mr. Room knew each other, but it noted, and again, looking specifically at the rationale, the statement that the court wrote, its rationale, this is in paragraph 21 of the decision below, it says, as a result, we find that the act was not intended to apply to gambling facilitated by a third-party website such as FanDuel, which allows a person to engage in head-to-head DFS contests with a stranger. This whole inquiry is not based upon whether people know each other, and it's not based upon whether FanDuel was acting as a house. It is strictly because trying to apply the LRA to a situation in the global, virtual, and anonymous environment would have massively different effects than the intents of the drafters could have required, and it's opposed to the language. You would have people, I'll give you a great example. I know someone that I'm playing with in California. They're in California, but I know who they are. They never set foot in Illinois. I played with them on a DFS website that the servers are all in New York. That doesn't give me a right to sue them in Illinois. There would be a lack of personal jurisdiction. So the lodestar here isn't whether you know somebody. It's trying to take this statute and apply it to all of the different types of situations that could apply on a virtual website, including people playing out from outside the country. I want to respond with some of the time that I have left to the idea that it doesn't matter because you could use Supreme Court Rule 224. Okay, we've cited numerous cases, even going back to Robson versus Doyle, that because of the penal nature of this statute, because you must know the persons who are involved, you cannot use the court in equity to find out who the losers are. That's what they tried to do in Robson. That was 109 years ago. That was a good rationale, and it remains so today. The current argument that the plaintiff first put into its petition for leave to appeal and never argued in the court below, and we've argued that that ought to be waived. And it wasn't actually used here, but it does describe an incredibly dangerous situation. But to that point, Supreme Court Rule 224 does not amend the Loss Recovery Act. It does not change the intent of the drafters. It does not change the literal construction. And the language of Supreme Court Rule 224 itself is also very important. The actual procedure here is it's 224A1I. It says, a person or entity who wishes to engage in discovery for the sole purpose of ascertaining the identity of one who may be responsible in damages. It's to provide people a way to get damages. The cases cited by the appellant that allowed the use of a discovery procedure, they're all defamation cases. They all knew the IP addresses. They were the people who suffered a damage, a tort damage, not bystanders or other people trying to apply a penalty. That is a significant difference. The committee comments go on to give examples and again uses the word damages. It talks about people who could benefit from this in civil cases, including Structural Work Act, products liability, malpractice, and negligence claims. It's not a mechanism to cure or expand the LRA. It can't do that. It comes I don't know the math, but it's well over 150 years later, the precursor to Supreme Court Rule 224. And then in my remaining moments, I want to just address briefly the Attorney General's opinion. That's the only argument being made by the appellant here for illegality. It was withdrawn. Without going through our whole argument, we produced the materials. It was clear in the litigation that was filed by FanDuel the very next day that the Attorney General said that her opinion was advisory only. She was not ordering the websites to do anything. She was not telling them they must shut down. And we know that nothing ever happened from that. And ultimately, 2 years later, those lawsuits were dismissed with the right of FanDuel and DraftKings, which filed its own suit, to come back and file it if it were ever necessary, but it was never necessary. So, Your Honors, I would ask the court to affirm. It is, the court can affirm on any basis. It could affirm on the basis that the record does not justify the expansion because there's not sufficient information about the DFS contest. It could affirm and should affirm on the basis that the statute itself is a key TAM statute or related. Its original origins were key TAM because the parties had to help and share some of the money with the state, but that's since changed. But it is a penal statute, and the case law, including Salzman, cited by the plaintiff, makes that very clear. The application with the hundreds of thousands of people, the millions of people that potentially, the millions of different contests that have been entered into, I can't predict how many lawsuits there will be, but I can predict that if there's a rule of this court that anyone who loses or anyone who finds out about a loser and they can use Supreme Court Rule 224 to file a lawsuit against a DFS website to get the information, or then hypothetical or anonymous persons, it will be profound. The courts will be deluged with people who are trying to defend on constitutional grounds that they never set foot in the state of Illinois. That clearly can't be the reason and purpose of a narrowly drawn and strictly construed statute. Thank you.
Thank you. Reply, Mr. Ring.
Okay, I'd like to address 3 points brought out by the defendant.
Mr. Ring, let me just ask you a general question first. I think it's a fair statement. The defendant pointed out that the game was not on the radar by the this type of game was not on the radar by the legislature in 1815, and the act has rarely been cited since the 1940s. I mean, it's here now. I mean, we're taking the case, we're listening to it. But tell me why you think that is.
Well, my opinion is that very few people are going to be suing on a friendly card game, and that's really where Zellers took place. It's an underground casino, it's a friendly card game, but now, since then, we have Nevada, we have a lot of states, including Illinois, having casinos around. There's gambling everywhere you can think of these days. There's a lottery that wasn't in existence. So there are many more avenues for gambling that did not exist in the 1800s. Almost every state in the United States has a form of gambling. We have the Indian tribe gambling in Wisconsin.
But a lot of that was there since 1940, right? I mean, Las Vegas was there for a long time, right? I mean, there was gambling, and it still hasn't. The act hasn't been cited much since 1940. I mean, we didn't just build casinos 2 years ago.
It's true the act has not been cited much, and as part of that answer, also the floodgates of litigation concerning this act, I don't see many lawsuits going on. There's not been any statistics cited by anybody or any reports saying that there's lots of lawsuits under the Loss Recovery Act, and we're going to even have more lawsuits if this court says you can sue for what you lost in a DFS contest. So I don't buy that either, that people will decide if they still want to be in a DFS contest, if they're going to sue for the losses. And businesses can adapt to that as well. They can say that if you want to participate, you have to waive your rights under this statute. Businesses can do a number of things that they, with their own corporate counsel, can decide how they want to adjust it. And here in Illinois, even though the Attorney General at the time decided not to take enforcement actions against the website persons, FanDuel and DraftKings at that time, doesn't mean that it's not legal. It's still a problem, but there's not going to be any enforcement by the Attorney General's office. That is another reason why it should be available to the victims if they choose to exercise their rights under that victim section of the statute. Now, counsel is talking about the penal nature of this, but in my beginning comments, I noted that this is remedial and not penal because we're looking at only the victim's loss, the $50 he lost. And when you look at remedial, it's the actual damages lost by that person. The penal is there's no damages associated with the amount of money the fine is or the damage against the victim or the wrongdoer. So here the penal aspect is for anybody in the world who's going to sue on behalf of the victim who did not sue. But here today we're only on Mr. Dubecker's loss as a victim, the remedial aspect that got his money back that he lost. So, but in both cases, remedial or the penal aspect, it has to be towards the purposes of what the statute intended, and that is to curb non-legal gambling. And that's a part of the legislator it's in. In terms of the previous litigation that didn't make it out of the lower courts, which the AG was involved in, both those plaintiffs in those lawsuits non-suited their case. So that's not really any kind of persuasive authority for this court to do anything. They were included, the AG's office, the state of Illinois, is a party defendant there, but as the briefs were filed, the parties decided to non-suit their case. And so that really has no effect here at all. In terms of whether or not this is illegal gambling, the Loss Recovery Act defines gambling. And the record itself, despite counsel's argument is very clear that it was gambling. And if the record, starting on page 12, the court-reported transcript talks about that Mr. Dubecker wagered the amount, and he talked about the amount of skill involved, and he talked about how similar it is to horse racing. And that is all contained in the record. The detailed complaint also talks about the risk of chance. But we really don't have to get into that discussion about this is illegal gambling, because that part of chance or skill is not appropriate for the discussion under this section of the statute. These are not actual participants. They are not people in a car race or a drag race, as that part of the statute discusses. So the lower court said it's gambling. The trial court said this is gambling. The record shows it's a game of chance. You have to pick out from the available athletes which athletes you want to pick out for your team, and they have to score a certain amount of points, more points than your opponents. It's risky. We don't know if the players are going to be on the team that day, the coach will play them that day, if they're going to be sick that day, if they have an injury from the night before. These are all chances of risk in any kind of athlete or athletic competition. So it clearly is gambling, and gambling, like I said, it was defined in the particular statute. Another point about the floodgates of litigation and the interplay of Rule 224, here Rule 224 was not involved in determining who to sue by Mr. Dubecker. Mr. Dubecker and Wu knew each other. But the identity of different people is used nowadays in many different aspects. For instance, when somebody downloads a movie or any kind of movie or TV show illegally from the internet, the company that owns the rights to that intellectual property can find the identity of the IPP address, and they can go from there after they determine the owner of the IP address. And so then after they get the owner of that IP address, they then file the lawsuit against that owner of the IP address. That happens every day in litigation. Federal courts are inundated with those kind of lawsuits on a regular basis of people getting sued by people who download movies illegally. And that's under the Copyright Act. So I don't think, as the law is fluid, that not knowing right away who your person that you lost money to should prevent a lawsuit like this we have today. So the floodgates of litigation, even though it's in a bigger atmosphere than your local card game, people know that if you're going to be suing somebody like FanDuel or DraftKings, you're not going to be invited back. They could simply bar you from participating in their future contests, and they would have a right to do that. So I think the business itself would curtail the floodgates of litigation that counsel is saying could happen if you reverse the lower court's decision. But the fact remains is that even though, and it's contained in the Lawrence case, is that we really can't substitute our judgment for what the General Assembly said. And this Illinois Supreme Court said clearly in the Lawrence versus Regent Realty case is that the responsibility for the wisdom or justice of legislation rests with the legislator. Under our system of government, courts may not rewrite statutes to make them consistent with their own ideas, orderliness, and public policy. So here we are left with what that very simple statute says in the Loss Recovery Act. It's a very simple section, 28.8, and it allows the victim to sue the winner for his gambling loss. Whether losers want to do that and be barred from their games later on, that's up to them and their choice, and that would prevent the floodgates of litigation that counsel has said would take place if the lower court's decision is reversed.
And the jurisdictional problems that were brought up by Mr. Gantz?
Well, here in this case, there's no jurisdictional issue. As to that taking place in the future, the litigation would discuss that. If there's no jurisprudence available or jurisdiction for the courts in Illinois to hear that, that would be something for those courts to determine at that time. I mean, it takes place in many states. Some states bar, like New York, for instance, bars FanDuel from participating. But all the cases that have been decided so far is the lawsuits against the DraftKings or FanDuel. And the courts have all uniformly said throughout the country that you can't be suing FanDuel. They're not the winners. They're not winning. They just get their little administrative fee. And the only other case that came with a large verdict was the Kentucky case, where the state of Kentucky sued and got the money, but the Supreme Court of Kentucky vacated that, saying that the state of Kentucky was not the loser of the money, the individual gamblers were. So again, goes completely back. You can't sue the intermediary, and you have to sue only the winner of your bet. Thank you very much.
Thank you. Case number 124472, Dubecker versus Wu, will be taken under advisement as agenda number 18. Mr. Ring, Mr. Gantz, we thank you for your arguments. You are excused, although I would ask that if your time permits, you be available to answer questions that the audience may submit to you after we recess. The court will be adjourning in a minute or so. As far as you and the audience, I want to thank you for your respectful attention to the arguments and to giving respect to this session of the Supreme Court. I would hope you as students might get at least an hour or two of credit for being here, so you can take that back to your teachers. What we do now is, this case is under advisement, as I indicated, both cases. We'll be discussing the case. The case is assigned to one of the justices for drafting a proposed opinion or order of the court or a ruling, and that's brought back to our full court. And when at least 4 people vote in favor of that, that can become the disposition of this case. So we don't announce it today. It'll be several weeks before we do. Thank you all again, especially to the staff of Lewis and Clark Community College and all of the people that were involved. Mr. Marshall, the Supreme Court will stand adjourned until 9 a.m. tomorrow morning at the Supreme Court building.
Supreme Court stands adjourned until 9 a.m. tomorrow morning at the Supreme Court building. We can loosen up now. Thanks for all of your attention. I think at this point here, we're going to try to have some of the attorneys, I think, that are willing to stand over or stay over. Josh, you're coming up, right? I think Mr. Rosen, you're going to come up as well. This gives you, this time in the audience, the opportunity to ask the attorneys questions. And we have 2 mics situated here, microphones, one right there, one over there.
Where would you like us?
I guess we'll wait and see if they ask any questions.
Oh, okay.
Stand by.
Oh, all right.
This is your last chance. If there's no questions, we're going to let you go. Good. Thanks very much. Yeah, no problem. Gave me the opportunity. Okay, can we have some quiet, please? We have some people that do want to ask some questions. Go ahead, sir.
All right, so I have a question for People v. Morger. So in the state's argument, he used the reasonable standard to apply that to Mr. Morger's restrictions on social media usage. Now, this is a question for the state, if you'd be willing. In Mr. Morger's conviction, he did not, well, in his crime, he did not use social media. So how would the social media restrictions be applied under the reasonable standard?
So
I don't know if this is on, but is this on? Oh, good, it's on. So that's a good question. Unfortunately, I can't answer it. Our policy is we don't comment on pending litigation. What I can say is that the briefs are all on the court website, I believe. You may have already read them, in which case I'm sorry. There's not further I can tell you. And you've heard the arguments. So unfortunately, that's all I can offer. Unfortunately, for my office at least, our participation is basically limited to responding to questions about the appellate process, drafting briefs, preparing for argument, that sort of thing.
All right, thank you.
Hi, I'm Kay. I am with Althoff Catholic High School. My question is people versus Morger. The ban on social media, he still has access to news websites, so technically he still has accessibility to modern society. What I've heard from both litigations is that they're just banning where it's under 18. So I'm just wondering what websites you think should be allowed. Like what you think is unjust about the ban on websites.
Unfortunately, we have a similar policy, so I can't get deeply into the facts of the case or to my position. I'd encourage you to read the briefs. But obviously, I think that the law is unjust as it is, and the state has a duty to defend the law, whether or not Mr. Schneider personally agrees with the law or not. So that's kind of where it stands, and I'm sorry if your question isn't answered.
Thank you.
I'll start answering questions about the other case. I can talk about it.
I don't know anything about it. We have one over here. Go ahead.
In light of the statements made, I'll just keep this short. It seemed like from all the advocate standpoints that there were several times where, from a trial lawyer standpoint, I proposed, it seems like this was personal to some of the attorneys involved, much more so than you might otherwise feel that these cases would be that. Is that true? Can you comment on that? Because it just seems to me there were certain comments made that it didn't seem like necessarily the individual involved or individuals, but there was a broader issue that was being raised here. True or false?
I'll say true because I take what I do personally and I want to win. But in my case, I'm generally advocating for the gaming industry. So I've been doing it for a long time, so I take it personally, and I want to see the gaming industry prosper and not be challenged.
Yeah, I think that's true for many lawyers. We're fighting for our clients, but we're also fighting for bigger issues that affect society on a daily basis. And so absolutely, I support the First Amendment right. And so it was easy for me to make that argument because I don't want to see that right disappear.
As lawyers, we always try to advocate for our clients, and learning through the case, the trial levels, and in my case, there were 2 appeals before it got to the Supreme Court stage. So we get pretty familiar with the case over a number of years. In our case, it was a 3-year process. And so we get so intertwined with the case, and we start actually believing our client's side many times, whether we like to or not. And this particular case is that we have a statute, and the statute has been amended, and we felt very strongly that the way the statute is written should be enforced, and we did feel like that.
So I'll take the other position. I don't take any of this personally. Good work. Nothing personal. To the extent that your question was about sort of packaging an oral argument, where someone says, I believe this, or I'm pretty sure that, or I'm not persuaded by this, often that particular framing is useful, especially before this court, where we're presenting an issue that is novel. There's no plain answer necessarily. Often the reason the court takes a case is because it requires the court's guidance. And so you don't want to present something as being an established point of law where it isn't. And so a way to soften a representation of a position is to say, it seems that, or I believe that, or my understanding is, so that the court is not misled in thinking that you're relying on some particular authority for that particular position.
That answer? Thank you.
Do you guys expect the rulings of these cases to be used in the future to define cyberspace and what is allowed there and what's not?
I think they will. That's called precedent. And so when a case comes out with an opinion, we're going to turn back to that case years down the road and say, what were the justices talking about? What were the facts of that case, and how can I apply them to the question I have in the next case? And so the other attorneys were talking about a law that was over 100 years old, and they're looking at case precedent that is that old, asking how can we apply what happened there to the case that we have here. So yes, I think that Packingham v. North Carolina and eventually the outcome of this case will help define or redefine what the internet is, what cyberspace means, and how we can exercise our rights online, if at all.
Hello, my question is mainly directed toward Mr. Rosen. You talked a lot about fine tailoring to each specific case. So who do you think should be in charge of that fine tailoring? Should it be according to a specific statute, the parole officer, or a specific judge?
Well, I think it's a collaborative process. We have a democracy. We have an executive branch, a judiciary branch, and a legislative branch. They each have unique powers, and part of that power is to check the other branches. And so narrow tailoring is something that all of the branches can think about. And in this case, we're asking the judiciary to consider whether or not a statute was narrowly tailored by the legislative branch. So I think all of members from each of those parties can have a role in interpreting and applying statutes, because that's the way our great democracy works.
No. Wrong case. Okay.
Hi.
Go ahead, I'm sorry.
Okay. Hi, my name is Emma Lane. I am from West High School. My question is for the FanDuel case, since you had given the example of if you're in Illinois betting on a game and then there's someone in California, that you can't sue the third party. How would you personally handle, because say then you wanted to sue the person that is in California. How would you, because that obviously crosses jurisdictions, how would you handle that if someone from Illinois wanted to sue someone from California, if it might
I'll
cross
just touch on that a little briefly. So if you have a diversity of citizenship, then there's a federal court allowance to sue. So if you have citizens from different states involved in a lawsuit, which is involving more than 75,000, then you get to sue in federal court. That's where you have federal court jurisdiction. So when you want to sue, and if you have a case under $75,000, then you have to sue in state courts. The only exception would that be if it's a federal statute. There's no minimum amount to sue for under a federal statute. Here, of course, there's no federal statute involved, as we know of. But if you want to sue under the Illinois statute, a citizen of the other state, you would have to, the venue rules require that you have to go to that state to sue. Otherwise, if you sue that person here from California and Illinois, then they can move that case to California. They might argue then that they're not subject to Illinois' laws, and you have a conflict of law situation, and California, of course, may have a law very similar, so whether or not we have that conflict of law to be determined by the judge in that case will remain if the statutes of each state are different. So it gets complicated, but there's always a venue to sue. One court has to make a decision.
It's not difficult to serve someone nationwide and then call them a defendant in a particular state, but your question is an excellent one for two reasons. Our Constitution puts limits on the extent to which someone can be dragged across the country and hailed into court. That's called the concept of personal jurisdiction. Someone who lives in California who has never been to the state of Illinois, did not purposely do business with someone in the state of Illinois, and had no reason to even think or know that they were doing business or entering a transaction, including if the transaction is alleged to be a wager in Illinois, cannot constitutionally be held to the jurisdiction of the courts in the state of Illinois. That's personal jurisdiction. It also applies going outside of the state, and the concept of extraterritoriality and the dormant commerce clause means that laws of a particular state can't be applied to people outside of the state. For example, one state can say that you can have a lottery and sell lottery tickets, but it can't do anything about what happens in the next state. You can't apply a tax on soda that's brought about in one state and say it's going to apply outside the state, or make people who buy soda outside the state. You can't cross borders in that way. You have to purposely avail yourself of the jurisdiction of the court. And that was one of the big problems that I felt existed in our case.
Thank you.
Sir? Go ahead.
I'm Ryan Lanier. I'm from Collinsville High School, and my question is for the People versus Morger. So I understand you brought up the idea of job employment through social media, and I think that I've been taught since the day I was born that there's consequences for your actions. I believe in second chances, but I feel like once you have those, you make those actions, you have the consequences that you're limited a little bit more. So, I mean, there's so many websites such as Job Recruiter, and you have your news sources, why you should be on some of these social media websites where even if you check that I'm 18 plus box, there are still minors present.
I think that's a great question. I do think it would also get really deep into the facts about this case. And so I think you've identified something that I can't speak to directly. But what you're getting at is, if there's a limitation, how far do we go? And that's certainly the question that I think both myself and the state are trying to find the correct answer. And so it's going to change over time. And maybe one year it extends to many more websites than another year. But I think you're right on to the issue directly.
Thank you.
Thank you.
Yes, ma'am.
I have a question for People versus Morger. In the in the short descriptions that we were given in the pamphlet that we were handed as we walked in, it says that Mr. Morger was convicted of criminal sexual abuse and aggravated sexual abuse. What would be the difference between those two terms?
Josh, come on now. Come on.
So, I don't have the statutory text in front of me, but the way that criminal statutes typically work is you'll have a base form of the offense, like battery, right? The argument did not go well, we're at odds, and he punches me in the face. He's committed battery. It can become aggravated battery if there are circumstances that make it more severe. So rather than punching me in the face, he stabs me with a knife. Well, that's now more serious, and so it becomes aggravated. There's also aggravating factors, like if I was over 60, then now I'm an older person. The General Assembly decided that I'm worthy of greater, or need greater protections, and so if you batter someone who's elderly, it becomes aggravated on that basis. So the difference between criminal sexual abuse and aggravated criminal sexual abuse is that there was some aggravating factor. It can have to do with the age of the victim. It could be something to do with the status of the victim, if the victim lacked the ability to consent due to some sort of disability, if there was a relationship of trust or something that could have caused an aggravating factor. But the specific one, in this case, I can't speak to.
Thank you.
Sir, go ahead.
My name is Andrew McKeever. I attend Missouri Baptist University. My question is generally, it's more general than focused specifically on either of the cases, I would say, and I feel like any of you could probably give some insight to it. So we've touched a couple times now how the Loss Recovery Act is, centuries old at this point. Would you consider building a case or defending against a case based on something so old to be more or less difficult? Would that be based on, say, the age of the act allowing for more precedent to draw from, or do you think the difficulty, if it's there, to be maintained based on the potential disconnect from when it was created to modern society?
I think Josh can take it.
So both. It depends on whether the old precedent is unhelpful for your position or helpful for your position. I mean, the Constitution is a very old document. And we are I don't think anyone in the position saying, well, it's so old it doesn't apply anymore, we can ignore it. On the other hand, there are documents that are extremely old, are never invoked by anyone for centuries, and then the question is, do they still have ongoing application in a modern society? Something that's very old and has never been cited is a thinner reed to rest your case on, something that's very old and has a long and rich precedent, vein of precedent on which to draw from. But antiquity can be a double-edged sword. It sort of depends on the nature of your case.
Thank you.
Yes, ma'am.
So oral arguments do not typically have such a large audience. How is it arguing before so many people? And do you think the benefit of sort of the civics lesson for high school students and college students, do you think it was met today? Do you think you helped maybe unshroud the mystery of the third branch of government a little bit today?
I would feel presumptuous to say that I helped. Speaking to your question about is it sort of the effect of having an audience, there is an audience at the Illinois Supreme Court House. It's smaller and possibly older, but it doesn't really make much of a difference. I mean, you're aware of people out of your peripheral vision when you're sitting at the table, but once the argument gets going, the only people who actually matter are the people on the bench, because the difference between oral argument and other forms of sort of public performance is that oral argument, you're not giving a speech. It's not really public speaking. You're having a conversation with the court to find out what are their concerns with your position, how can you persuade them that those concerns are not worth ruling against you. So once you're at the podium, and frankly, once your opponent's at the podium and you're watching the court see how they're interacting with him, what sorts of concerns they're telegraphing through their questions to him, writing down, oh, he said this, that's ridiculous, or whatever, or he said this, I'm really in trouble. Whatever it is, everyone from your seat back is sort of out of your mind. Hopefully.
Well, I really felt the energy, so I enjoyed it. This is probably the biggest crowd that any of us lawyers will have for an oral argument at appeal. Usually it's family members, your client, and the 10 or 12 other lawyers that also have arguments that day, unless it's the U.S. Supreme Court where I haven't been. But I hope it's useful for your purposes. Directly to your question, I didn't do anything here today that I would not have done whether there were 4 or 5 or 200 people in the audience. Where an audience comes into play might be something like a jury trial. I would do something differently if I was trying to grasp the attention of 12 jurors as opposed to the court. But yeah, once the lights are on over here and you're worried about how much time you have, the blinders are on and you're just going.
Good question. Yes, ma'am. Go ahead.
Okay, so how y'all doing? My name is Tasia, and this question is for the state of Illinois versus Mr. Morger. So you mentioned that it's important for the criminals to be rehabilitated back into the modern world, which is correct. So why isn't it a job for the probation officer or the parole officer to monitor what the offender do on the internet? Wouldn't that be a job for him to make it easier?
I might be mistaken, but I think that they can monitor activity on the internet. So I think you're right that is one way we could assist in people's rehabilitation.
Thank you. Y'all have a nice day.
Thank you. Yes, ma'am.
Hi. So my question is about the People versus Morger case. So in my opinion, voting is a privilege which is taken away. So shouldn't the internet be a privilege that could also be taken away?
Well, so just so everyone else knows, if you commit a felony and you're convicted, you can lose your right to vote, you can lose your right to bear arms, you can lose lots of other rights. And some of them are also privileges. And so the question today is which one of those can we take away and for how long and to what extent? So I think you know our positions from the briefs and from the arguments, but these rights are inalienable, but we can limit them in certain sections for certain people. And so that's the question that we're trying to get at today, yeah.
Okay, thank you guys.
Yes, sir.
Hi, so for People versus Morger, I have a specific question about how recent federal Supreme Court precedent affects this case. So in 2017, the Supreme Court ruled that the president specifically cannot ban people from his account because of various things. And that is resulting in following litigation and applying that broadly among all public officials on Twitter specifically. What implications does that have in the cyberspace? What implications does that have specifically with free citizens versus parole and those in the criminal system? And how does that change things going into the future with this country?
How much time do we have?
So, I don't think I'm qualified to answer that question, frankly. Unfortunately, the areas I'm qualified to speak to are the specific case, which I can't speak to, and then sort of more generally appellate practice. Certainly, I think it is fair to say, and you've identified this, I think everyone's on board, that things are changing pretty rapidly. And one of the issues that states and governments are running into is trying to understand how things work online. So we're in the process of working that out. Twitter has made things very exciting.
Thank you.
Yeah.
Yes, ma'am.
Hi, my name is Kayla, and I'm from Balboa West High School, and my question is for the gentleman on the end. You seem very passionate about what you do, so my question for you is, how did you decide that you wanted to do this for the rest of your life?
I'm afraid that I can't discuss that. No, actually, that's a great question. I originally set out to be a doctor, but I got waylaid in college with English classes and just really just went to law school. I wanted to be a professional, and I went to a litigation firm. I took the best job that I could get in Chicago, and I just sort of ran with it. But I, in terms of courtroom, I view it as a performance. I mean, it's certainly an academic exercise, but when you're in front of a jury or you're trying to be persuasive, I view this as a performance. So I had no idea there would be this many people here, but I was happy to see this many people here. Because I want to put on a good performance, because I do believe as long as the performance is genuine and logical and is genuine to the record and not disingenuous, you're more powerful. But you have to want to perform. You want to have to really read all the cases. There's a lot that goes behind this. It's not just a script.
Thank you.
Go ahead.
Hi, I'm from EHS, and my question is for the lawyers of People versus Morger. So let's say that a sexual offender was allowed to be on a website or an app like Snapchat, and on that app, if I have my maps on, you can see me wherever I am at that exact moment. Now, do you believe that they should be able to use that map, or do you think that if they are allowed to use certain apps, that there should be certain restrictions on what settings that they can use?
Well, I think the first question is whether or not even something like Snapchat would qualify under the definition in the law. And that's what's hard, because we can't just list the websites. There's going to be more next week. So we need to use language to try to define what is acceptable use and what isn't.
Thank you. I think we have one more.
Hello, I'm from Belleville East, and I actually had two questions. But the first one is for the Dubecker versus Wu case. So if the judges decide not to apply the Recovery Act, would they have to get rid of it since it is so old?
I'll let my counsel.
So the justices, their authority is only to rule on the facts of this particular case, because the separate powers of our state show that you have the Illinois General Assembly. They can only repeal the laws. As you saw from the criminal case before us, the judiciary can say a law is unconstitutional and not enforceable, but that's not the case in the Dubecker case. So they can say that under the facts and they write their opinion on why they don't believe the facts of our case is supportive of the law, deny the relief, but the law will still be on the books until the legislator, the General Assembly, does something, amend, modify, or repeal the statute.
And then my last question is about the People versus Morger. So, okay, so let's say that the person on probation does go on a social networking site, and how would they get caught, or if they do get caught, what would be their punishment?
I feel like we can talk about that.
Yeah, I think so too.
We
Yeah.
can actually talk about. So, if someone's on probation, they have a probation officer that is sort of keeping track of them, and so if they possess a firearm when they're not allowed to possess a firearm, they go online to a website they're not allowed to go online to. The ways that a probation officer might find that out are the sorts of ways that police might find things out, right? They have access, they can stop by and maybe conduct searches of the person's computer or home. They can interview witnesses. Someone reports, I saw this person doing this thing, I'm not sure they're allowed to do that. And then I think the second part of your question was then what happens? So what happens then is if the state determines that this is a serious violation of probation and they think that it warrants revocation, the state would then petition the court to revoke probation. And if the court was persuaded by a preponderance of the evidence that probation had in fact been violated, then the court would have the option to revoke probation, in which case the court could impose whatever sentence it could have imposed for the original crime. So he punched me in the face, he gets probation, but the original sentencing range was up to 6 months in prison, let's say, or 6 months in jail. If on probation he violates the terms of his probation and the court revokes that probation, then it can impose a jail term of up to 6 months.
So would they be, so if it's up to 6 months, can they extend it based on what the person does on social media?
No, the sentencing range is the sentencing range.
Okay.
So it's whatever the underlying offense was. So in this case, I think we mentioned it was 3 to 7 because it was a class 2 felony. So if probation had been revoked and the court had imposed a prison term, it would have had to have been between 3 and 7 years.
Okay, thank you.
For People versus Morger, one of the things I was surprised that wasn't like stated is I was surprised that People didn't argue that social media is not needed for rehabilitation because there's ways to rehabilitate outside of social media. So how would you have responded if the People had argued that social media is not necessary for rehabilitation?
Save the hard question for last, is that right? One more? Okay. Well, so I think you raise a really good point, and I probably would have been stuck for a little bit thinking about it. I think the issue is that we're not talking about what's necessary. We're talking about what's allowable under the Constitution. How far is too far? And so certainly you can still exercise your freedom of speech rights, going to the corner and talking about whatever you want to talk about, politically or religious ideas. But under the current law, it does close off this brand new forum for all of us. We still don't know really what the public square on the internet looks like. But the Supreme Court made it clear that it was a public sphere and that it will be treated like that, at least for the time being.
Thank you.
We have 2 more there and 1 more. I got an announcement down here too. Go ahead. Yeah.
Hello, my name is Anna Harla. My question is, as a lawyer, are you able to put your own opinion into your argument when you make it?
So, not really. I mean, obviously life is different as a private attorney because you don't have to accept every client. So there's, depending on how well your practice is doing, you can be a little pickier. For a government attorney, our job is to represent our client. Counsel's job is to represent the defendant. Our job is to represent the state. So I have an obligation to defend a statute that's been enacted by the General Assembly, and whether I think it was a good idea or a bad idea or have no thoughts on it at all, that's my position. In the process of preparing for a case, when we're researching the briefs, and generally you sort of come around to believe your position because you've been devoting all of this energy into it, finding reasons why your position is not only defensible but correct. So there's a little bit of a chicken and the egg. You will typically find that prosecutors believe in the guilt of the people that they're prosecuting, and you will generally believe that you'll generally find that defense attorneys believe that the prosecution has failed to bear their burden of proving that guilt, because that's sort of necessary to do your job well, I think, is to buy in at some level.
Thank you.
Thank you.
Hi, so my question is that most of these social media platforms that we were talking about, most of them are private businesses. Does that play a role in what can be regulated and what cannot?
I think it does, yeah, because we're not talking about purely public forums. We're talking about a forum that's owned by a private company. But what we have to remember in this case is that it's not that private company doing the restricting, it's the government doing the restricting. So private companies, private businesses are always allowed to, well, not always, but often are allowed to limit constitutional freedoms, and there's nothing you can do about it unless the government is involved. And so our righs are exercised against overreach of government, not necessarily the overreach of private companies.
Thank you.
It's also important to you can walk, that's fine. To know that there are different kinds of regulations. And without going into it in detail, there's regulations of what people are allowed to do, which may affect their ability to access private businesses. And then there's regulations of those private businesses. So imagine, if you will, that there was a restriction that sex offenders could not work at daycares. Obviously, some daycares are private businesses, so that has an incidental effect on private businesses, but the regulation is not on private businesses, it's on the sex offender's ability to work certain places.
One more.
Hi again, it's me. This time, this is going to be for People versus Morger. My thing on is that we all know that in this day and age, even though there are apps and websites that are only for 18 and up, we all know that there's people that catfish, even underage kids. They make fake profiles saying that they're 18 or above. What if it was on some social media site where the minor in question would be like 16, 17, but using perhaps like Tinder? And then the defendant was in contact with them and sending messages, explicit messages back and forth, but the defendant didn't know. Would that technically still be in violation of the defendant's probation, or no, since he had no idea that the minor in question was underage? How would you deal with that?
Yeah, that's a really hard question, I think, for the judges and for the legislature and for us as well. I'll say that, minors are not supposed to be on a website like Tinder, and each of these websites have terms and conditions that say they're not allowed to be there. So they are violating those terms and conditions if they create accounts. But I think you've hit it square on the head that this is really tough to litigate. This is really tough to describe in words of what limits should be put in place, because we can't just name the websites. Yeah. There's going to be the same website that comes out a week later, and then it won't be in the law. And the process that the legislature goes through just goes too slow to limit behavior this way. So we need to figure out how we can describe what type of behavior is acceptable and what type of behavior isn't. And I think that's why, if you look at the conditions, some of the conditions of probation were do not contact minors. I mean, there's nothing really more you can do than that other than locking the person up and physically keeping them away from minors. But in this case, the court didn't think that was appropriate. So it's a difficult question, and I think it's one that we're all working towards answering.
Okay, thank you.
Okay, good. Thank you.
I just wanted to make a comment as a member of the bench here in this county. On behalf of all of us, I want to thank you all, you attorneys, for your outstanding preparation and delivery and performance. I want to thank Jim Cimarosa, Carolyn Grousball, Chris Bonjean, and all the other people, Skip Robertson, I see, Marcia Meese, for doing all the work to bring this to our county. And most of all, thank the Supreme Court and Justice Carmeier, Chief Justice Carmeier. We're honored here, and I think they deserve a round of applause for all the work they did here today.
If nobody has any further questions, I think we're done. Thank you much for coming.
Thank you.
Thank you.